Before we begin, a quick and important disclaimer. The historical analysis, financial concepts, and legal discussions presented in this video are strictly for educational and entertainment purposes only. I am not a financial advisor, a family law attorney, or a certified public accountant. Divorce law, especially concerning the division of complex assets like a 401k, qualified domestic relations orders, and marital property, varies heavily by state and jurisdiction within the United States. Historical case studies and past legal precedents do not guarantee any specific modern legal outcomes. You must conduct your own due diligence and consult with licensed legal and financial professionals regarding your unique circumstances before making any decisions about your marriage, your retirement accounts, or your financial future. Imagine watching half of your life savings vanish overnight, not because of a catastrophic stock market crash, not because of a bad investment in a volatile tech startup, but simply because a family court judge signed a piece of paper. Now imagine a reality far more terrifying. Living in a society where you possessed absolutely no financial assets to split in the first place because your entire legal identity, including your right to own a single coin, was entirely erased the very second you said the words "I do." The modern process of splitting a 401k during a divorce is widely considered a financial bloodbath. A highly complex, emotionally draining labyrinth of tax penalties, early withdrawal fees, and bitter, protracted negotiations over decades of compound interest. But the foundational laws dictating who gets what, the very DNA of our modern family court system, were not invented in the 1970s. They were forged in the fires of early American society, an era defined by rigid legal doctrines where the concept of marital property was a matter of sheer survival. If you think separating a Vanguard target date fund from your soon-to-be ex-spouse is a complicated nightmare today, wait until you hear exactly how colonial courts handled the aggressive division of livestock, dowries, generational land grants, and future wealth. Today we are tearing apart the modern 401k divorce by exposing its deeply buried, shocking historical roots, revealing exactly how the financial ghosts of the 17th and 18th centuries are still haunting family courtrooms today. For the modern American, the 401k represents the ultimate financial safety net. It is, for the vast majority of the middle class, the single largest asset they will ever own, often surpassing the equity in their primary residence. It represents decades of sacrifice, deferred gratification, early mornings, late nights, and the quiet, steady accumulation of wealth designed to ensure dignity in old age. When a marriage dissolves, this asset becomes the primary battlefield. But to truly understand why the legal system treats your retirement account the way it does, we have to travel back to a time before the Revenue Act of 1978 established the modern 401k. We must look at early American society, specifically the 17th and 18th centuries, to examine the profound legal framework known as coverture. Under English common law, which the American colonies aggressively adopted, coverture dictated that upon marriage, a woman's legal rights and obligations were subsumed by those of her husband. Sir William Blackstone, the legendary English jurist whose writings heavily influenced early American law, famously wrote that by marriage, the husband and wife are one person in law, and that person is the husband. This meant that any personal property a woman brought into the marriage, any cash, livestock, or goods, instantly became the absolute property of her husband. He could sell it, gamble it away, or leave it to someone else in his will. This brutal historical reality is the exact opposite of what we see in modern asset division, yet it is the very baseline from which our modern laws overcorrected. Today, when a couple divorces, the courts utilize either an equitable distribution framework or a community property framework to divide a 401k. In a community property state, the wealth accumulated in a 401k during the marriage is generally considered to be owned 50-50, regardless of whose name is on the account or who earned the paycheck. This modern concept of equal ownership is a direct, revolutionary rebellion against the early American doctrine of coverture. But the transition from a husband owning absolutely everything to a court meticulously dividing a 401k down to the exact penny was not a swift one. It was a slow, agonizing evolution driven by historical trends in women's rights, shifting economic landscapes, and the realization that leaving a divorced spouse destitute was a massive burden on the state. In early America, divorce was exceptionally rare and incredibly difficult to obtain. In many jurisdictions, you could not simply file for divorce because you were unhappy. You required a literal act of the state legislature. It was a highly public, deeply humiliating process that required proving severe fault, such as absolute desertion or blatant adultery. Because wealth was not stored in digital index funds but rather in physical land and tools, the division of assets was a matter of physical survival. If a divorce was granted, courts had to figure out how to keep both parties from starving. This led to the early primitive versions of alimony and the aggressive protection of the dower right. The dower right was a legal provision ensuring that a widow was entitled to a one-third interest in her husband's real estate for the rest of her life. This historical concept is absolutely critical to understand because it is the direct ancestor of modern federal regulations protecting your spouse's interest in your 401k. Today, under the Employee Retirement Income Security Act, commonly known as ERISA, a spouse is automatically the beneficiary of a 401k plan. You legally cannot designate someone else without your spouse's explicit, notarized written consent. This modern federal law is nothing more than the modernized, financialized version of the colonial dower right, designed to prevent a spouse from being secretly disinherited and left to freeze in the winter of their life. This video masterclass is designed to give you an unparalleled, deep dive understanding of exactly how modern wealth is divided when a marriage ends, by showing you the historical mechanics of property law. We are going to solve the overwhelming confusion surrounding modern retirement asset division by mapping out exactly how we got here. You are going to learn about the historical precedents that dictate why your ex-spouse might have a legal claim to the compound interest on a 401k contribution you made 10 years ago. We will explore detailed case studies of how early Americans used complex trusts and separate estates to shield their wealth from coverture, and how those exact same ancient legal strategies have evolved into the modern prenuptial agreements and asset protection trusts used by high-net-worth individuals today. Furthermore, we must examine the terrifying modern mechanism used to physically split a 401k, the Qualified Domestic Relations Order, or QDRO. A QDRO is a highly specialized legal decree that orders the administrator of a retirement plan to give a portion of the account to the alternate payee, usually the ex-spouse. The complexity of drafting a QDRO is notorious. A single misplaced word or incorrectly calculated percentage can result in massive, irreversible tax penalties, or the complete loss of thousands of dollars. The QDRO is the modern equivalent of an ancient court of chancery decree. In early America, because the strict common law offered no flexibility, individuals had to appeal to courts of equity, or chancery courts, to seek fairness when the rigid laws of coverture resulted in extreme injustice. These equity courts possessed the unique power to look beyond the strict letter of the law and make rulings based on fundamental fairness, much like how a modern family court judge uses the principle of equitable distribution to divide a 401k not necessarily 50-50, but in a manner the court deems fair based on a multitude of factors, including the length of the marriage, the earning potential of both parties, and the historical contributions to the household. By mastering the historical trends and potential outcomes of property division, you will no longer view a 401k simply as a retirement account, but as a complex legal battlefield governed by centuries of evolving precedent. To understand how this battlefield operates in the year 2026, we must analyze a modern scenario and instantly cross-reference it with a colonial legal crisis. Imagine if we look at a typical American couple right now. Let us call them Michael and Emily. Michael has spent the last 25 years aggressively funding his employer-sponsored retirement account. By early 2026, the portfolio has reached exactly $1.4 million through a combination of employer matches, relentless biweekly contributions, and the compound interest of the broader stock market. Emily paused her corporate career for a decade to raise their 3 children and manage the household working part-time with no retirement benefits. When the marriage inevitably dissolves, Michael might assume that because his name is on the digital login and his employer funded the match, that money belongs exclusively to him. This is the exact moment the ghost of early American family law steps into the modern courtroom. In a community property state like California or Texas, the court does not care whose name is on the digital portal. The court views the marriage as an absolute economic partnership. Every single dollar Michael contributed during the legal span of the marriage is classified as community property, meaning Emily is entitled to exactly half. But how did we arrive at this strict mathematical division? Let us rewind exactly 300 years to 1726 in colonial Williamsburg, Virginia, to examine a historical parallel. A wealthy tobacco planter named Thomas marries a woman named Elizabeth, who brings a massive dowry of silver livestock and a fertile tract of land into the marriage. Under the rigid doctrine of coverture, the very second they finalized the marriage, Thomas legally absorbed all of Elizabeth's assets. She ceased to exist as an independent financial entity, If Thomas was reckless, if he accrued massive gambling debts or made terrible business deals, his creditors could legally seize the land and silver Elizabeth brought to the marriage. If they faced a rare colonial divorce, Elizabeth would not walk away with 50% of the tobacco yield. She would be entirely at the mercy of the Chancery Court, begging for a tiny fraction of alimony simply to avoid debtor prison or starvation. The sheer financial terror of coverture forced wealthy colonial families to invent complex legal loopholes. Fathers who wanted to protect their daughters' inheritance from reckless husbands utilized a brilliant legal mechanism called a separate estate. They would place the wealth into a trust managed by a male trustee specifically designated for the sole and separate use of the daughter. The husband legally could not touch it. This colonial separate estate is the direct foundational ancestor of the modern prenuptial agreement and the asset protection trusts used by high net worth individuals today. By establishing these trusts, early Americans were essentially drafting the very first early versions of a legal decree dividing and protecting assets before the marriage even began. When we look at the modern divorce process, we see these exact same concepts of absolute protection and brutal taxation playing out step by step. If Michael and Emily from our 2026 example live in an equitable distribution state like New York or Florida, the court process becomes even more complicated than a straight mathematical split. Equitable distribution does not mean equal. It means what the presiding judge deems fair based on a massive list of historical variables. The judge will analyze the length of the marriage, Emily's lost earning potential, the tax consequences of liquidating assets, and the standard of living established during the decades together. Once the judge signs the divorce decree declaring Emily is owed $600,000 from Michael's retirement portfolio, the nightmare is only just beginning. Michael cannot simply log into his account, sell the mutual funds, and wire Emily the cash. If he attempts this massive financial blunder, the Internal Revenue Service will immediately hit him with a mandatory 20% tax withholding and an additional 10% early withdrawal penalty because he is under the age of 59 and a half. He would lose hundreds of thousands of dollars in a matter of seconds. This is where the modern legal system demands the implementation of a qualified domestic relations order. A qualified domestic relations order is an extraordinarily precise legal directive. It must be drafted by a specialized attorney, approved by the specific retirement plan administrator, and signed by the federal judge. The document legally instructs the plan administrator to segregate the $600,000 and roll it directly into an entirely new retirement account controlled by Emily. This direct rollover is the only legal pathway to avoid catastrophic tax penalties. The drafting of this document is a high-stakes procedure. If the attorney uses the wrong valuation date, if they fail to account for the market gains or losses that occurred between the date of separation and the date the funds are actually moved, Emily could lose tens of thousands of dollars in compound interest. If the plan administrator rejects the wording, the entire process halts, driving up billable hours and trapping the funds in legal limbo. This precise, agonizing bureaucratic process mirrors the highly scrutinized property transfers of the 18th century. When colonial courts were forced to divide physical property to settle a dower claim, surveyors had to physically measure the land, assess the quality of the soil, and carefully document the borders to ensure the widow received her exact one-third life estate. Today, instead of measuring acres of soil, actuaries and forensic accountants are measuring historical rates of return, vesting schedules, and premarital contribution tracing. The complexities multiply exponentially when we factor in the timeline of the contributions. Let us assume Michael had $200,000 in his account before he even met Emily. Under the laws of almost every single state, that $200,000 and all the subsequent growth tied directly to that specific seed money is classified as separate property. It is entirely immune from the divorce settlement. But proving exactly how much of the current $1.4 million balance grew from the premarital money versus the marital contributions requires a terrifyingly complex mathematical process known as tracing. Forensic accountants must go back through decades of monthly statements calculating exact market fluctuations, dividend reinvestments, and specific fund allocations to separate the modern equivalent of the husband's separate estate from the marital community property. Michael must prove without a shadow of a doubt exactly what portion of the account belongs to his premarital timeline. He cannot simply provide a statement from the month before the wedding. He must hire a financial analyst to perform a coverture fraction calculation or a detailed tracing analysis. This involves pulling the exact historical data of the market, the precise dividend yields, and the expense ratios of the specific mutual funds he held 25 years ago. The analyst must recreate a parallel universe where no marital contributions were ever made, demonstrating exactly what the original $200,000 would be worth today. This process can take months and cost tens of thousands of dollars in expert witness fees. If Michael cannot produce the physical or digital statements from 25 years ago, the court will legally presume the entire $1.4 million is marital property. The burden of proof is entirely on the person claiming the separate property. This heavy burden of proof echoes the strict evidentiary standards of early American chancery courts. When a colonial widow petitioned the court to enforce her dower rights or to protect her separate estate from her deceased husband's creditors, she had to produce the physical trust documents. If the paper was lost in a fire or destroyed by a flood, her legal protection vanished instantly, and she was left destitute. Today, the fire that destroys the evidence is a corporate merger that wipes out old digital records, or a bank changing its data retention policy. The historical mechanism of proving ownership remains exactly the same. You must have the immutable records or you surrender the wealth. These historical trends in modern financial mechanics reveal a deeply flawed, highly combative system, designed to force two people to untangle a lifetime of intertwined financial DNA. The transition from a society where a woman owned nothing to a society where courts demand forensic accounting to split a digital retirement account is one of the most fascinating legal evolutions in American history. But the most shocking element is not how the courts divide the money today. The most shocking element is the secret legal mechanism that was buried in the federal tax code in the late 20th century that fundamentally rewired how the government views your retirement savings. This hidden clause completely destroyed the concept of individual ownership and turned every single retirement account into a ticking time bomb of marital liability. And to understand exactly how this invisible trap was set, we have to look closely at what happened on a specific day in Washington, D.C. that changed family law forever. The date was August 23, 1984. On this specific day in Washington, D.C., the federal government signed into law the Retirement Equity Act. To the average American worker clocking into their factory job or sitting at their corporate desk, this sounded like a mundane piece of bureaucratic legislation. But to family law attorneys and financial planners, it was a tectonic shift that fundamentally rewired the DNA of American marriage. Before this exact date, the newly invented 401k and traditional pension plans were protected by a titanium vault known as the Anti-Alienation Clause. This clause was originally established under the Employee Retirement Income Security Act of 1974, commonly known as ERISA, and it was designed to protect a worker's retirement from aggressive creditors. If you went bankrupt or got sued, your retirement money was legally untouchable. The problem was that family courts across the country were classifying ex-spouses seeking their fair share of the marital assets as mere creditors. This meant a husband could accumulate massive wealth in his employer-sponsored plan, divorce his wife, and the federal law would legally block the state family court from giving her a single penny of that specific account. She was locked out by the very federal code designed to protect the American worker. To fix this massive inequity, Congress did not just tweak the rules. They resurrected a ghost from early American society. The Retirement Equity Act introduced a federal mandate that instantly transformed an individual private retirement account into a joint marital asset by default. This law created the modern spousal protection rules, which dictate that the moment you enter into a legal marriage, your spouse automatically becomes the sole primary beneficiary of your 401k. It does not matter what your last will and testament says. It does not matter what you typed into your company's digital HR portal before you met them. The federal government decreed that your spouse owns the right to inherit that money, and they legally possess a massive claim to its value during a divorce settlement. Let us look at a hyper-specific case study, set in the current year 2026, to see the terrifying power of this invisible trap and its potential outcomes. Imagine a 35-year-old software engineer named David. David has been aggressively saving in his 401k since he was 22, amassing a portfolio of $500,000. David loves his aging mother and specifically listed her as the sole beneficiary of his 401k in case of a tragic accident. In 2026, David marries a woman named Jessica. They keep separate bank accounts, they split the rent, and they believe their finances are completely independent. What David does not realize is that the very second the officiant pronounces them legally married, his mother is entirely erased from his 401k beneficiary designation. Under the strict federal mandates, born in 1984, Jessica is now the automatic absolute beneficiary of that $500,000 account. If David is involved in a fatal accident on his honeymoon, his mother receives absolutely nothing and Jessica inherits $500,000. The only way David can keep his mother as the beneficiary is if Jessica signs a highly specific federally regulated waiver that must be witnessed and stamped by a licensed notary public or a plan representative acknowledging that she is willingly surrendering her legal right to his wealth. This modern notarized waiver is not a new concept. It is the exact modern reincarnation of the colonial American dower release. In the 17th and 18th centuries, the law recognized that a widow needed to be protected from a husband who might secretly sell off all his land and leave her destitute. This was the dower right, which guaranteed her a one-third life estate in his real property. If a colonial man wanted to sell his tobacco farm to a neighbor, the buyer would absolutely refuse to finalize the transaction unless the man's wife was brought into the room separated from her husband to ensure she was not being physically coerced and forced to verbally acknowledge to a magistrate that she willingly released her dower rights to that specific parcel of land. If the magistrate did not record her explicit consent, the sale was invalid, and the wife could legally reclaim the farm from the buyer after her husband died. The modern 401k spousal waiver is simply the digital era equivalent of the colonial magistrate pulling the wife into a separate room. The asset changed from physical acres of tobacco land to digital shares of a mutual fund, but the profound legal principle of mandatory spousal protection remains absolutely identical. This historical trend of forced asset protection creates incredibly complex potential outcomes when a marriage dissolves. Because the federal government elevated the spouse from a mere creditor to a legally protected co-owner of the retirement wealth, the traditional anti-alienation clause had to be pierced. The vault had to be cracked open to allow for equitable distribution during a divorce. But the Internal Revenue Service was not simply going to allow people to withdraw hundreds of thousands of dollars tax-free under the guise of a marital split. They needed a highly regulated, extremely restrictive key to open the vault. That key was the invention of the Qualified Domestic Relations Order, or QDRO. The creation of the QDRO is perhaps the most heavily misunderstood and dangerous mechanism in modern family law. It is a terrifying bridge between state family court and federal tax law. When a state judge signs a divorce decree ordering David to give Jessica $200,000 of his 401k, that state judge actually has absolutely zero legal authority over the federal retirement plan administrator. Vanguard, Fidelity, or Charles Schwab do not care what a local county judge says because they are governed by federal ERISA laws. The state order is entirely powerless on its own. It must be translated into a QDRO, which is a specific federal decree that explicitly instructs the plan administrator to violate the anti-alienation clause and carve out a piece of the account for the alternate payee. To understand the gravity of this, imagine if early American colonists had to appeal directly to the King of England every time they wanted to divide a small plot of land in Virginia. The layers of bureaucracy would ensure that any minor error would result in total catastrophic failure. This is exactly what happens with QDROs in 2026. The drafting process requires identifying the exact legal name of the retirement plan, which often changes due to corporate mergers and acquisitions. It requires defining the exact mathematical formula for the division. Will the ex-spouse receive a flat dollar amount or a percentage of the total account? If it is a percentage, does that percentage include the market gains and losses that occurred between the date of the separation and the exact date the funds are physically transferred? If David and Jessica separate in January, but the QDRO is not finalized and executed until December, the stock market might have experienced a massive 20% bull run. If the attorney who drafted the QDRO failed to include specific language accounting for market fluctuations, Jessica might only receive the flat valuation from January, missing out on tens of thousands of dollars in compound growth. Conversely, if the market crashed, David might be forced to liquidate an overwhelmingly disproportionate amount of his remaining shares to satisfy a flat dollar amount ordered 10 months prior, permanently crippling his ability to retire. The exact wording of this document dictates the financial trajectory of the rest of their lives. The sheer precision required to navigate this modern system is a direct evolution of the meticulous property laws that govern the survival of early American families. The difference is that a colonial mistake meant a drawn-out dispute over property lines, whereas a modern mistake triggers the absolute wrath of the Internal Revenue Service. And the IRS does not offer equitable fairness, they only offer strict mathematical penalties. If a QDRO is rejected by the plan administrator because of a single typographical error, the funds remain trapped in bureaucratic limbo. If an ex-spouse attempts to move the money without the QDRO fully executed, they trigger a massive irreversible taxable event that can decimate the entire portfolio overnight. But what happens when the exact opposite occurs? What happens when the legal documents are drafted flawlessly? The judge's signature is dry, and the federal plan administrator accepts the order, but the underlying asset itself is built on a financial structure so complicated that physically splitting it is mathematically impossible without triggering a massive hidden tax bomb that destroys both the husband and the wife. We must now turn our attention to the darkest corner of retirement asset division, where the historical concept of the hidden colonial estate collides with the terrifying reality of modern illiquid phantom assets. To grasp the concept of an illiquid phantom asset in modern finance, we must first examine its historical equivalent in the colonial era. In 1750, a wealthy merchant living in Boston might possess a massive portfolio of wealth on paper, but that wealth might consist entirely of a shipment of highly valuable indigo currently crossing the treacherous Atlantic Ocean. If that merchant faced a sudden legal separation or sudden death, the colonial courts were tasked with dividing an asset that was entirely theoretical. The ship could sink, the cargo could spoil, or pirates could intercept the vessel. The asset had massive projected value but zero immediate liquidity. The court could not physically divide a cargo hold that was 3,000 miles away. Fast forward to the current year 2026, and family courts across the United States are grappling with the exact same impossible mathematical paradox hidden inside the modern American retirement portfolio. When most people think of a 401k, they envision a highly liquid collection of mutual funds tracking the S&P 500. They assume that if a judge orders the account split, a plan administrator simply sells the shares and wires the cash. But for high-earning professionals, executives, and individuals utilizing self-directed 401k structures, the reality is drastically different. Their retirement accounts are often stuffed with modern phantom assets. These include unvested employer stock matches, restricted stock units, or shares of private equity funds that have been aggressively rolled into the tax-advantaged shell of the 401k. These assets generate a massive theoretical dollar amount on a monthly statement, but they are locked behind strict corporate vesting schedules. You cannot legally cash them out today, even if your life depended on it. Imagine a 42-year-old corporate executive named Robert living in Chicago in 2026. Robert is going through a highly contested divorce with his wife Amanda. Robert has a 401k statement that proudly displays a total account value of $2.5 million. However, upon closer forensic inspection, $1.2 million of that total valuation is composed of unvested employer stock and deeply illiquid private real estate investment trusts held within a specialized tier of his retirement plan. If Robert quits his job tomorrow or gets terminated during a round of corporate layoffs, that $1.2 million legally vanishes into thin air. He does not own it yet. He merely owns the future promise of it, provided he meets a strict set of ongoing employment conditions. It is a phantom. But Amanda and her aggressive legal team do not see a phantom. They look at the monthly statement and see $1.2 million of marital property that they demand be divided immediately. The legal mechanics of splitting this phantom wealth present a catastrophic problem. A state family court judge cannot simply issue a standard qualified domestic relations order and force the plan administrator to transfer half of the unvested stock to Amanda. The federal regulations governing the corporate retirement plan explicitly prohibit the transfer of unvested assets to a non-employee spouse. The plan administrator will flatly reject the federal decree, sending the entire legal process into a chaotic gridlock. Because the modern system cannot divide the asset today, the court is forced to utilize historical legal workarounds that mirror how colonial magistrates handled the future expected yield of an unharvested tobacco crop. To solve this modern crisis, forensic accountants employ highly complex mathematical formulas to establish a future lien against Robert's potential wealth. The most common method is known as the time rule formula. This requires the financial experts to calculate a precise fraction. The numerator of this fraction represents the exact number of months Robert and Amanda were legally married, while Robert was actively earning the unvested stock. The denominator is the total number of months required for that specific block of stock to fully vest. This calculation creates a percentage known as the coverture fraction. The court then issues a deferred distribution order. This means Amanda gets nothing today. Instead, she must wait agonizing years in the shadows, silently tethered to Robert's employment status. If the stock finally vests in 2029, Amanda will automatically receive her calculated percentage. But if the company goes bankrupt or Robert is fired because the stock goes to zero and Amanda absorbs the total loss, she is forced to take on the extreme volatility and risk of a phantom asset she has absolutely no control over. Because the idea of remaining financially tethered to an ex-spouse for a decade is psychologically unbearable for many people, lawyers often push for a secondary historical strategy, known as the immediate offset. This strategy involves Robert keeping all of the unvested phantom assets in his 401k, while giving Amanda an equivalent amount of value from a safe tangible asset today. For example, Robert might surrender his entire ownership stake in the primary marital home, allowing Amanda to keep the physical house free and clear in exchange for him retaining his full $2.5 million phantom 401k. This echoes the exact historical trends of colonial dower settlements, where a widow might surrender her legal claim to a contested unsurveyed land grant in the violent Ohio River Valley in exchange for sole ownership of a small safe cottage back in Massachusetts. However, this immediate offset strategy is where the most devastating financial traps in modern family law are sprung. When individuals in 2026 attempt to trade real estate equity for 401k balances, they routinely ignore the catastrophic historical reality of taxation. If Robert trades $500,000 of home equity for $500,000 of unvested 401k funds, he is committing financial suicide. The equity in the primary residence is generally post-tax money. When Amanda eventually sells that house, the first $250,000 of profit is entirely tax-free under modern capital gains exemptions. Robert's 401k, however, is entirely pre-tax money. When Robert eventually accesses that $500,000 in retirement, the Internal Revenue Service will tax every single penny at his highest ordinary income bracket. Robert did not trade a dollar for a dollar. By ignoring the embedded tax liability of the 401k, he essentially traded a dollar for 65 cents, permanently crippling his future net worth. The complexity deepens into a total legal war zone when the phantom assets inside the 401k are not publicly traded stocks but private equity shares or proprietary algorithms. How do you establish the value of a company that is not listed on the New York Stock Exchange? Robert will hire valuation experts who will aggressively argue that the private stock is highly risky, heavily discounted, and practically worthless. Amanda will hire her own forensic economists who will project massive future cash flows and argue the private stock is worth millions. The modern family courtroom transforms into an exhausting battle of competing financial models, burning through hundreds of thousands of dollars in legal fees, simply trying to guess the future value of an asset that currently does not exist in a liquid state. These brutal mathematical gymnastics and intense valuation wars all operate under one massive fundamental assumption. They assume that both spouses are acting in good faith. They assume that the historical data provided on the digital 401k statement is accurate, and that the money is quietly waiting to be divided. But what happens when the 401k is intentionally weaponized by a malicious actor? What happens when a highly educated spouse realizes they are heading for a divorce and decides to use the dense, impenetrable regulatory framework of ERISA, not to protect their wealth, but to legally and systematically siphon it away, right in front of the judge? As we transition from the mathematical theories of phantom assets, we must now expose the tactical financial warfare used by sophisticated individuals to drain a 401k, utilizing obscure plan loans, hidden offshore feeder funds, and the terrifying exploitation of early withdrawal hardship exemptions. The moment an individual decides a marriage is irreversibly broken, a silent countdown begins. For a sophisticated, financially literate spouse, the months leading up to a formal divorce filing in the year 2026 are not spent in marriage counseling, they are spent executing a calculated campaign of financial depletion. The 401k, typically viewed as a heavily fortified fortress of marital wealth, can easily be transformed into a porous vessel if you know exactly which regulatory levers to pull. This tactical maneuvering is not a modern invention. It is the exact same strategy utilized by desperate colonial landowners who sought to hide their liquid wealth from aggressive creditors or estranged wives by converting physical silver into unrecorded fictitious debts across the Atlantic. Today, the silver has been replaced by digital mutual funds, and the unrecorded debts have evolved into aggressive 401k plan loans. Let us examine the mechanics of a 401k loan to understand how a seemingly innocent federal provision can be weaponized into a devastating wealth transfer mechanism. Imagine a 50-year-old executive named Christopher living in Seattle in 2026. Christopher anticipates that his wife Laura will file for divorce within the next year. His 401k currently sits at $600,000. Under standard IRS guidelines, a participant is generally allowed to borrow up to 50% of their vested account balance, capped at a maximum of $50,000. Christopher logs into his plan administrator portal and quietly initiates a $50,000 loan. The stated reason could be anything from home repairs to debt consolidation. The plan administrator liquidates $50,000 of his mutual funds and deposits the cash directly into a private checking account Laura knows absolutely nothing about. To the untrained eye, the total value of the 401k has not changed. The monthly statement still shows a $600,000 balance. However, the composition of that balance has been fundamentally poisoned. It now consists of $550,000 in actual market securities and a $50,000 promissory note representing Christopher's obligation to pay himself back. But Christopher has absolutely no intention of paying it back. He takes the $50,000 in liquid cash, withdraws it in staggered increments, and converts it into untraceable physical assets or highly volatile offshore digital currencies. When Laura finally files for divorce and the court demands the division of the 401k, the phantom nature of the loan is exposed. The $50,000 is physically gone. If Christopher defaults on the loan, the IRS treats it as a taxable distribution, slapping him with severe income tax liabilities and early withdrawal penalties. But Christopher intentionally absorbs this tax hit because he successfully removed $50,000 of liquid marital capital from the negotiating table, hiding it entirely from the family court judge. This exact same deceptive playbook was heavily utilized in early American society, specifically during the late 18th century, to bypass the strict requirements of the dower right. Imagine a wealthy colonial merchant in Philadelphia who wished to disinherit his wife. Because the law strictly required that a widow receive a 1/3 life estate in his physical real property, the merchant could not simply sell his land without her explicit recorded consent. Instead, he would engage in the creation of fictitious, highly exaggerated debts. He would conspire with a trusted business partner in a distant colony, drawing up massive promissory notes that claimed he owed the partner an insurmountable sum of money. When the merchant died, or if a legal separation was somehow forced, the estate would suddenly appear entirely bankrupt. The creditors, armed with these fake promissory notes, would legally seize the land, effectively erasing the widow's dower right, because the debt superseded her claim. The wealth was secretly funneled out the back door, while the widow was left fighting over an estate that was mathematically underwater. The modern equivalent of this fictitious colonial debt is the terrifying exploitation of the 401k hardship withdrawal exemption. While a plan loan is capped at $50,000, a hardship withdrawal allows an individual to pull potentially massive sums of money out of their retirement account if they can prove an immediate and heavy financial need. The IRS defines these needs as medical care expenses, costs directly related to the purchase of a principal residence, tuition, or payments to prevent eviction or foreclosure. A highly malicious spouse planning a divorce in 2026 can artificially manufacture these exact crises. They might deliberately stop paying the mortgage on a secondary investment property, triggering an intentional foreclosure notice. Armed with this legitimate legal document, they petition the 401k plan administrator for a massive hardship withdrawal of $100,000 to save the property. The administrator, seeing a valid foreclosure notice, approves the distribution. The spouse receives the cash, pays off the artificially created debt, and effectively converts $100,000 of pre-tax marital retirement wealth into heavily contested real estate equity that they can aggressively obscure through shell companies or fraudulent conveyances. By the time the forensic accountants arrive during the divorce discovery process, the money has been washed through multiple layers of manufactured crisis. But the ultimate vanishing act, the most sophisticated and dangerous method of draining a retirement account, involves the high net worth utilization of the self-directed 401k and obscure offshore feeder funds. Standard 401k plans managed by massive financial institutions restrict investments to a small menu of approved mutual funds. However, business owners and independent contractors can establish a solo 401k or a self-directed plan that grants them absolute control over the investment vehicles. They are no longer restricted to the S&P 500. They can legally invest their retirement funds into physical real estate, private businesses, and most dangerously limited liability companies that they themselves manage. Imagine a 2026 scenario involving a successful entrepreneur named Victoria. Victoria controls a self-directed 401k worth $2 million. Facing an imminent, highly contentious divorce, Victoria establishes a brand new LLC in a business-friendly jurisdiction like Wyoming or Delaware, where corporate ownership structures are deeply shielded by extreme privacy laws. She then directs her 401k to purchase a 100% ownership stake in this new LLC. On paper, the 401k still possesses $2 million in value. It simply holds shares of an LLC instead of shares of Apple or Amazon. But Victoria, acting as the manager of that LLC, now controls the physical bank account containing the $2 million in cash. She then executes a massive, highly obscure international wire transfer, funneling the entire $2 million into an offshore feeder fund located in the Cayman Islands or Belize. She signs investment contracts locking the money up in a 7-year, highly illiquid foreign real estate development project. When her husband and his attorneys demand their 50% share of the marital retirement wealth, Victoria simply hands them a stack of corporate documents showing that the money is legally bound in a foreign jurisdiction tied to an international construction project that will not yield a single penny for almost a decade. She has effectively removed the asset from the immediate jurisdictional reach of the United States family court system. This is the exact strategy used by colonial smugglers who wish to hide their wealth from the British Crown or local magistrates. Instead of keeping their silver in a local Boston bank, they would load it onto a schooner and invest it into aggressive, highly risky sugar plantations in the West Indies. The wealth still belonged to them, but it was physically located in a jurisdiction where the local colonial courts had absolutely zero authority. They weaponized geography to achieve total asset protection. Today, individuals in 2026 do not need a schooner, they only need a fiber optic internet connection and a specialized corporate attorney to move millions of dollars across international borders in fractions of a second. These extreme tactics demonstrate that a 401k is not merely a passive savings account. In the hands of a highly motivated, legally sophisticated individual, it is a dynamic instrument of financial war. The courts, however, are not entirely blind to these aggressive maneuvers. When a judge discovers that a spouse has intentionally dissipated marital assets, manufactured fake hardship withdrawals, or hidden wealth in offshore LLCs, the legal retaliation is swift and utterly devastating. But how exactly does a modern family court judge pull that money back when it has been legally shielded in a foreign trust or spent on untraceable assets? To answer that, we must dive into the most aggressive draconian legal weapon available to the modern justice system, a concept so powerful it can instantly rewrite property titles and seize assets from completely innocent third parties who never even knew they were involved in a divorce. When a spouse in 2026 attempts to vaporize their 401k through fraudulent transfers or offshore shell games, they are playing a high-stakes game against a legal doctrine that has its roots in the medieval English courts of equity. This doctrine is known as the constructive trust. In the eyes of a modern family court, if you take marital property and hide it under a different name or inside a different legal entity, the law does not see a new owner. It sees a thief. The court possesses the extraordinary power to declare that the third party holding those assets is not actually the owner, but merely a constructive trustee, who is legally obligated to hold that property for the benefit of the betrayed spouse. This is the ultimate judicial reset button. It allows a judge to pierce through the corporate veil of a Wyoming LLC or a Cayman Island feeder fund and effectively say the law does not care about your paperwork. This concept of judicial intervention to prevent unjust enrichment is the modern evolution of the colonial writ of nexit. In early American society, if a husband was suspected of preparing to flee the jurisdiction with all the marital assets to avoid his financial obligations, the court could issue this writ to physically arrest him and prevent him from leaving the colony until he provided sufficient security for his debts or his wife's support. The modern constructive trust is the digital arrest of the assets themselves. Instead of locking the man in a cell, the judge locks the assets in a legal cage regardless of whose name is on the bank account. To see this in action, consider a case study involving a 2026 scenario with a surgeon named Marcus living in Atlanta. Marcus realizes his marriage to Sarah is over. Before filing, he takes $300,000 from his self-directed 401k and invests it into a private medical technology startup owned by his brother. He signs a contract making the investment look like a legitimate business transaction with a 10-year lockup period. He believes he has successfully moved the money out of the marital estate. However, during the discovery phase, Sarah's forensic accounting team uncovers the wire transfer. The judge determines that Marcus committed a fraudulent conveyance designed to deplete the marital estate. Under the power of a constructive trust, the judge orders the medical technology startup to return the $300,000 immediately or grants Sarah a direct ownership stake in the startup equivalent to the value of the stolen 401k funds. The brother, who thought he was helping Marcus hide money, is now legally entangled in a nightmare of corporate litigation. This aggressive clawback mechanism is mirrored by the historical trends of colonial estate law, where executors were held personally liable for any mismanaged or hidden funds. If a colonial executor tried to siphon off wealth from a deceased man's estate to avoid paying the widow's dower, the court would hold that executor in contempt and could seize the executor's own personal property to make the widow whole. The modern family court judge uses this same philosophy through a process called waste or dissipation of marital assets. If the money is truly gone spent on high-stakes gambling or untraceable luxury travel, the judge will not simply shrug their shoulders. They will perform a mathematical rebalancing. If Marcus spent $300,000 of marital 401k money, the judge will award Sarah an extra $300,000 from the remaining liquid assets such as the equity in the marital home or the joint savings accounts. Marcus ends up with a depleted retirement and a much smaller share of the tangible property, essentially paying back the stolen money with interest in the form of legal fees and lost equity. This judicial power extends even further into the realm of the Qualified Domestic Relations Order. We have already established that a QDRO is the key to unlocking a 401k, but in 2026 courts are increasingly using what is known as a survivor benefit mandate. This is a terrifyingly specific clause that can be inserted into a QDRO, which legally forces the retirement plan to treat the ex-spouse as if they were still the current spouse for the purposes of death benefits. Imagine if Marcus remarries a few years after the divorce. He starts a new life and a new family. He assumes his new wife will inherit his remaining 401k. But if the QDRO from his first divorce contains a survivor benefit mandate, his first wife Sarah retains a superior legal claim to those funds. Upon Marcus' death, the plan administrator is legally required by federal law to bypass the current grieving widow and send the checks to the ex-wife. This creates a situation where the financial consequences of a 401k divorce can literally reach out from the grave to haunt a second or even third marriage. The historical precedent for this is found in the rigid structure of the life estate in early American society. When a colonial man died, his property was often split between his children and his widow. However, the widow only held a life estate in her portion, meaning she could live on the land and use its resources, but she could not sell it or leave it to anyone else in her will. Upon her death, the land automatically reverted back to the children from the first marriage. The law prioritized the original bloodline over any subsequent relationships. The modern QDRO survivor benefit mandate is the 21st century version of this reversionary interest. It ensures that the marital wealth accumulated during the first partnership remains tethered to that partnership regardless of how many decades pass or how many new marriages occur. But the complexity does not stop at death. We must also address the brutal reality of the early withdrawal exception for QDROs. This is one of the very few instances in the entire United States tax code where the 10% early withdrawal penalty can be legally waived. If Sarah receives her $300,000 share of Marcus' 401k via a properly executed QDRO, she has a one-time choice. She can roll it into her own IRA and keep it tax-deferred, or she can take the cash out immediately. If she takes the cash, she still owes ordinary income tax, but the 10% penalty is waived because the distribution was made pursuant to a QDRO. For many spouses in the midst of a high-stress divorce, this sudden access to a massive pile of liquid cash is an irresistible temptation. However, this is a psychological trap that mirrors the colonial trend of selling off future interests for immediate survival. In the 18th century, a widow might be so desperate for cash that she would sell her future dower rights to a land speculator for pennies on the dollar. She received a small bit of silver today but surrendered her long-term security and a place to live in her old age. Similarly, a modern spouse who cashes out a 401k share today to pay for legal fees or a new lifestyle is effectively burning their future for the sake of the present. They lose out on the exponential power of compound interest that would have turned that $300,000 into over $1 million by the time they reached retirement age. This brings us to the most controversial and least understood aspect of the 401k divorce: the valuation of the non-financial contribution. In early American society, the law struggled with how to value the labor of a wife who managed a massive household, brewed beer, made clothes, and raised 8 children but never earned a single shilling in wages. Today, 2026 family courts are dealing with the exact same issue, but with much higher stakes. How do you quantify the domestic labor that allowed the other spouse to focus entirely on their career and max out their 401k? The courts have developed a specific set of criteria to answer this, but the battle over these numbers is where the most intense emotional and financial warfare takes place. As we move into the next phase of this masterclass, we are going to expose the hidden formulas used by courts to put a price tag on a marriage, and how a stay-at-home spouse can legally claim a portion of a retirement account they never contributed a single penny to. This involves the shocking intersection of gender roles, labor theory, and the brutal cold math of the actuarial table. The valuation of domestic labor in a 401k divorce is perhaps the most contentious intersection of historical tradition and modern economic theory. In early American society, the labor of a wife was legally viewed through the lens of consortium and service. A husband was entitled to the labor of his wife, and in exchange, he provided shelter, food, and protection. There was no mathematical formula to calculate the market value of churning butter, spinning wool, or managing a household of 10 children, because that labor was seen as a duty inherent to the marriage contract. However, as we moved into the industrial and eventually the digital age of 2026, the American legal system began to recognize a profound economic truth. The ability of one spouse to maximize their 401k contributions is often directly subsidized by the unpaid labor of the other. Imagine a 2026 case study involving a couple named Brian and Sophia. Brian is a high-level project manager who earns $300,000 a year and has maxed out his 401k for 15 consecutive years, amassing a balance of $800,000. Sophia left her promising career in marketing 16 years ago to raise their 4 children. She has $0 in her own retirement account. During the divorce proceedings, Brian's legal team might argue that because Brian was the one who went to the office, Brian was the one who negotiated the raises, and Brian's name is on the paycheck, the $800,000 is the fruit of his individual labor. But modern family courts utilize the partnership theory of marriage to dismantle this argument. The court views Sophia's 16 years of domestic management not as a hobby or a duty, but as a silent capital contribution to Brian's 401k. By managing the household, Sophia provided Brian with the time and mental bandwidth to excel in his career. She effectively offloaded his domestic responsibilities, allowing him to work late, travel for business, and secure the promotions that fueled the 401k growth. To quantify this, forensic economists in 2026 use replacement cost modeling. They calculate what it would have cost the couple to hire a full-time live-in nanny, a house manager, a chef, and a chauffeur for 16 years. When those figures are tallied, the market value of Sophia's labor often exceeds Brian's total 401k balance. This historical trend in shifting from service-based duty to labor-based equity is why a stay-at-home spouse is almost always awarded a significant portion, often exactly 50%, of the working spouse's retirement assets. This evolution mirrors the historical transition of the dower right from a mere life estate to an absolute interest. In the 17th century, a widow was merely a tenant on her husband's land. She could use it but never own it. By the mid-19th century, through various married women's property acts across the United States, the law began to recognize that a wife had a vested, equitable interest in the marital estate. Today, that interest is codified in state statutes that mandate the equitable distribution of all assets acquired during the marriage, regardless of whose name is on the account. However, the math becomes incredibly cold and calculated when we introduce the actuarial table. In 2026, if the 401k is being divided not as a lump sum but as a stream of future income, the court must account for life expectancy. If Sophia is awarded a portion of Brian's future pension or a structured withdrawal from his 401k, the insurance companies and plan administrators look at her health, her age, and her statistical likelihood of living to age 90. This is a direct echo of the colonial annuity system, where wealthy individuals would purchase the right to a yearly payment for the rest of their lives. In those days, if you outlived the statistical average, you won. If you died early, the estate kept the balance. In a modern 401k divorce, if the QDRO is not drafted with specific survivor benefits, and the non-employee spouse dies before the funds are fully transferred, the wealth can effectively revert to the employee spouse or stay within the plan, leaving the heirs of the non-employee spouse with nothing. This is the ultimate actuarial gamble. To further complicate the depth of this masterclass, we must examine the impact of the 401k catch-up contribution. For spouses over the age of 50, the IRS allows for extra contributions to accelerate retirement savings. In 2026, these catch-up limits have increased significantly. If a couple is divorcing in their mid-50s, the court must decide how to handle these last-minute injections of capital. If Brian uses marital funds to make massive catch-up contributions while the divorce is pending, is he attempting to secure his own future with shared money, or is he building a larger pot for both to split? This leads to the concept of post-separation credits. If Brian continues to contribute to his 401k after the legal date of separation but before the final decree, those specific dollars are generally considered his separate property. However, the market growth on the marital portion of that account during that same period still belongs to both parties. Tracing these market gains requires the use of the Hunt formula or the Majoska's formula. Depending on the jurisdiction, these are mathematical algorithms that separate the growth of the marital seed from the growth of the separate seed. It requires a month-by-month analysis of the Dow Jones or S&P 500 performance relative to the specific dates of contribution. If the stock market experiences a massive rally during the 2 years it takes to finalize the divorce, the difference between a percentage-based split and a flat dollar split can be worth hundreds of thousands of dollars. Imagine if Sophia is awarded $200,000 in 2024, but the divorce is not finalized until 2026. If the market grew by 15% in that time, and the order was drafted as a flat dollar amount, Sophia loses $30,000 of growth that she technically helped earn through her historical domestic contributions. If the order was drafted as a percentage, she participates in that growth. This is why the precision of the QDRO drafting is the difference between financial survival and long-term poverty. We are seeing a massive historical trend in 2026 where the legal system is moving away from the all-or-nothing approach of the colonial era toward a fractional ownership model. But this fractional model creates a lifelong tether between ex-spouses. They remain linked by the performance of a mutual fund, the decisions of a plan administrator, and the ever-changing tax codes of the federal government. This tether can become a noose if one spouse decides to retire early or takes a disability discharge. But what happens when the 401k isn't just a collection of stocks? What if the 401k was used to fund a family business? Or what if it contains specialized employer stock that has restrictions on who can own it? We have touched on phantom assets, but now we must go deeper into the corporate divorce, where the retirement account and the family business are so inextricably linked that you cannot cut one without killing the other. In the next part, we will explore the terrifying reality of the double dip, where a spouse tries to claim a share of the 401k and a share of the business income that funded it, creating a legal paradox that can bankrupt even the most successful executives. This involves the controversial intersection of asset valuation and future income projections that determines who truly wins the economic war of the 401k. To understand the mechanics of the double dip, we must first look at how 2026 family courts define the relationship between a business and the retirement accounts it feeds. In the colonial era, a merchant's shop and his personal savings were often the same physical chest of coins. If a court divided the chest, the shop's ability to purchase future inventory was crippled. Today, the separation is purely digital, yet the economic entanglement is more dangerous. The double dip occurs when a court treats a business-related asset as both a piece of property to be divided and a source of income for calculating alimony or child support. This is a mathematical paradox that can lead to potential outcomes where a business owner is effectively paying their ex-spouse twice from the same dollar. Imagine a 2026 case study involving a business owner named Gregory. Gregory owns a specialized civil engineering firm and has utilized a solo 401k to stockpile $1.2 million. Because he is the employer and the employee, he has been able to funnel maximum profit-sharing contributions into this account for years. During the divorce, his wife, Catherine, seeks 50% of that 401k as part of the property division. However, Catherine's legal team also argues that because the business generated the high income that allowed for those massive 401k contributions, the business value itself should be appraised and divided. Furthermore, they demand alimony based on Gregory's historical income, which includes the very profits he was redirecting into the 401k. This is where the financial war becomes a battle of valuation methodologies. If the court awards Catherine $600,000 from the 401k as property, and then also uses the business's cash flow to set a high alimony payment, Gregory is being squeezed from both sides of the ledger. Historical trends in American jurisprudence generally disfavor the double dip, but the line between a divisible asset and a stream of income is notoriously thin. In many states, once a 401k is divided as property, the income generated by the remaining half of the account cannot be used to calculate support. However, if the business continues to fund the 401k post-divorce, that new income is absolutely on the table. This mirrors the colonial struggle with the concept of the quit rent. In early American society, a landowner might owe a perpetual annual payment to a higher lord or the crown. When that land was divided in a marital or estate dispute, the court had to decide if the value of the land should be reduced by the projected cost of the future quit rents. If they didn't, the person receiving the land was essentially being handed a liability disguised as an asset. Today, the quit rent is replaced by the embedded tax liability of the 401k. If Gregory hands Catherine $600,000 in 401k assets, he is handing her a future tax bill. If he hands her $600,000 in cash from a savings account, he is handing her pure liquid value. To navigate this, forensic accountants in 2026 use a technique called the capitalized excess earnings method. They look at what a reasonable salary for Gregory would be if he were merely an employee, and then they classify any profit above that salary as the business's goodwill. This goodwill is what gets valued and divided. But the intersection with the 401k is where most professionals fail. If a portion of that excess earnings was already captured and stored in the 401k, it must be backed out of the business valuation to avoid the double dip. This requires a granular audit of every single employer match and profit-sharing contribution made over the last decade. The high-stakes nature of this valuation is compounded by the 2026 economic environment. With fluctuating interest rates affecting the capitalization rates used by appraisers, a business that was worth $5 million last year might be worth $4 million this year. If the 401k is composed of stable government bonds while the business is a volatile tech-heavy firm, the spouse who takes the 401k might actually end up with a superior financial position, despite a lower nominal valuation on paper. This is a complete reversal of the historical trend, where land was always the preferred asset. In the modern era, the liquidity and tax-deferred growth of a 401k can often outweigh the headaches of owning an illiquid closely held corporation. Furthermore, we must examine the role of the 401k loan in this corporate divorce. If Gregory borrowed $50,000 from his 401k to fund a piece of equipment for his business, the court must decide how to categorize that debt. Is it a personal liability that reduces his share of the 401k? Or is it a business debt that reduces the value of the engineering firm? The way this $50,000 is characterized can shift the final settlement by tens of thousands of dollars. In early American society, debt was often localized. Everyone knew who owed what to the local blacksmith. In 2026, debt is a complex web of internal plan loans, corporate lines of credit, and personal guarantees. Imagine if Gregory's business fails 6 months after the divorce because he was forced to liquidate too much working capital to pay out Catherine's share of the marital estate. He is still on the hook for the alimony payments based on his 2025 earnings, but his 401k is now half its previous size and he no longer has a functioning business to rebuild it. This is the nightmare scenario of the corporate 401k divorce. It echoes the historical tragedies of the 18th century where a bad harvest following an expensive estate division could lead to the total collapse of a family's generational wealth. The only way to mitigate this risk is through the use of a constructive buyout or a structured settlement. Instead of a QDRO that immediately rips $600,000 out of the plan, the parties might agree to a long-term payment plan where Gregory pays Catherine her share over 10 years, using the business's future profits. This preserves the capital inside the 401k for continued growth, but it leaves Catherine as a creditor of her ex-husband's business. This is a return to the colonial era's reliance on private credit and personal trust, a system that functioned reasonably well until the first missed payment. The court's ultimate goal in 2026 is to achieve a clean break, but as we have seen, the financial DNA of a 20-year marriage is almost impossible to fully untangle. Every dollar in a 401k carries a history of labor, a future of taxation, and a present-day valuation conflict. But even if you manage to divide the business and the 401k perfectly, there is one final trap waiting in the shadows. It is the one thing that both the colonial magistrates and modern federal judges fear most: the total collapse of the underlying currency or the market itself. In a world of digital assets and high-frequency trading, what happens to a QDRO if the very fund it is supposed to divide ceases to exist or is frozen by a global financial crisis? As we move into the final chapters of this deep dive, we must confront the reality of the 2026 market volatility. We will look at how the timing of a divorce filing during a market crash can be used as a predatory financial weapon, and why the person who files first often dictates the valuation date that can save or cost them a fortune. This leads us to the most aggressive strategy of all: the tactical use of the market cycle to maximize the division of the 401k. We are moving from the law of the courtroom to the law of the ticker tape, where the timing of a signature is worth more than a decade of work. The strategic timing of a divorce filing in the year 2026 has become as critical as the legal arguments themselves because the modern 401k is essentially a living organism that breathes with the rhythm of the global markets. In early American society, the value of a marital estate was relatively static. 100 acres of Virginia soil or a brick storefront in Philadelphia did not fluctuate 30% in value based on a Federal Reserve announcement or a geopolitical crisis in the Middle East. However, in our current financial landscape, The difference between filing for divorce on a Tuesday versus a Friday can result in the gain or loss of a small fortune. This is due to a legal mechanism known as the valuation date. The valuation date is the specific moment in time the court chooses to freeze the value of the marital assets for the purpose of division. Imagine a 2026 case study involving a couple named Stephen and Monica. Stephen is a senior engineer at a major aerospace firm with a 401k portfolio worth $900,000, heavily weighted in high-growth technology stocks. The market has been on a historic bull run for 18 months. Monica, realizing the marriage has reached its end, observes that the tech sector is showing signs of a major correction. If Monica files for divorce immediately while the market is at its peak, and the court establishes the filing date as the valuation date, she locks in her claim to 50% of that $900,000 high water mark. If the market crashes by 25% during the 12 months it takes to litigate the divorce, Stephen is still legally obligated in many jurisdictions to pay Monica her $450,000 share based on the peak valuation. Stephen would be forced to liquidate almost his entire remaining account just to satisfy the original court-ordered amount, leaving him with next to nothing. This predatory use of market cycles is a direct evolution of the historical trend of speculative litigation in the 18th century. During the various land bubbles of the colonial era, such as the Ohio Company speculations, savvy litigants would time their property disputes to coincide with peak land appraisals. They sought to have the court award them a cash equivalent of their interest before the bubble inevitably burst. When the crash came, the person holding the physical land was ruined, while the person who walked away with the court-ordered cash settlement survived. In 2026, the 401k is the new frontier for this type of financial maneuvering. The complexity intensifies when we consider the difference between a static valuation and a fluctuating valuation in the final divorce decree. If the legal team for the non-employee spouse is sophisticated, they will push for a percentage of the account as of the date of distribution, including all gains and losses. This ensures they are protected if the market rises but exposed if it falls. If they believe a crash is imminent, they will fight tooth and nail for a specific dollar amount fixed at the date of filing. The strategic gamesmanship involving these dates is so intense that forensic accountants now use algorithmic modeling to show the potential outcomes of different valuation date scenarios to judges, attempting to prove that one date or another would result in an unconscionable windfall or a devastating loss. Furthermore, we must examine the tactical use of the 401k contribution freeze. In the current year 2026, many high earners who anticipate a divorce will quietly stop contributing to their 401k months before the filing. By redirecting that cash into separate, less visible accounts or increasing their lifestyle spending, they ensure that the marital pot being divided is as small as possible. This is a modern echo of the colonial practice of selling the harvest standing, where a farmer would sell his entire future crop for cash under the table before a creditor or an estranged spouse could place a lien on the barn. The modern 401k participant is essentially doing the same thing by refusing to build the asset that they know will soon be split. But what happens when the 401k contains assets that are not easily valued by a daily ticker tape? We have discussed phantom assets, but now we must address the rise of alternative investments within self-directed 401ks, specifically digital assets and tokenized real estate. In 2026, a 401k might hold a significant position in a decentralized finance pool or a fractionalized ownership stake in a commercial skyscraper. These assets are notoriously volatile and often lack a centralized exchange to determine a fair market price. Imagine if Stephen's 401k held $200,000 worth of a specific digital currency that crashed by 90% the day after Monica filed. If the court uses the filing date valuation, Stephen is effectively being asked to pay Monica a share of money that no longer exists in the physical or digital world. This leads to the equitable deviation argument, where a spouse begs the court to move the valuation date because of extraordinary circumstances. In early American equity courts, a magistrate could grant relief if a literal act of God, like a fire or a flood, destroyed the property before it could be divided. Today, a market flash crash is the modern act of God, and the battle over whether a court should grant relief for a paper loss is where the most aggressive 2026 legal precedents are being set. This focus on timing also applies to the concept of the vesting cliff. Many corporate 401k plans use a 5-year vesting schedule for employer matching funds. If a spouse files for divorce in month 59 of a 60-month schedule, they are essentially attempting to claim a portion of a massive windfall that hasn't officially landed yet. The litigation often focuses on whether that future vesting is a mere expectancy, like a colonial inheritance that might never come, or a contingent property right that can be valued and divided today. The precision of the 2026 actuarial calculations used to value these contingencies is staggering, involving probability distributions and discounted cash flow models that would have baffled the legal minds of the 18th century. This intersection of market volatility and legal timing creates an environment where the 401k is no longer a static retirement bucket, but a dynamic weapon. The person who understands the rhythm of the market and the speed of the court system can effectively amplify their share of the wealth or shield their losses. This is the ultimate masterclass in financial self-defense within the family court system. By analyzing these historical trends and potential outcomes, it becomes clear that the division of a 401k is not just a legal process. It is a sophisticated financial trade where the stakes are the next 30 years of your life. However, as we approach the conclusion of this deep dive, we must look at the most permanent and perhaps most tragic aspect of the 401k divorce. We have talked about the math, the timing, and the law, but we have not yet addressed the long-term systemic impact on the American retirement dream. When a 401k is halved, the power of compound interest is not just divided, it is mathematically broken. The time required to regrow that wealth to its original trajectory often exceeds the remaining working years of the individual. This is the gray divorce crisis of 2026, where individuals in their 60s are finding that the legal victory of a successful 401k split leaves both parties with a standard of living that is a shadow of what they spent their lives building. But there is one final, obscure federal rule that most attorneys miss. A rule that can actually allow an ex-spouse to collect a check from the Social Security Administration based entirely on their former partner's work history without reducing the partner's benefit by a single cent. This hidden pillar of retirement security is the final piece of the puzzle, and it provides a rare moment of cooperation in an otherwise brutal system. To understand how this works and how to integrate it into a total divorce strategy, we must look at the final overarching legacy of the American family law system and the future of the 401k in a post-marriage society. The integration of Social Security benefits into a 401k divorce strategy represents the final, often overlooked pillar of American retirement security. While the 401k is a private, employer-sponsored asset, Social Security is a federal entitlement program that operates under its own distinct set of rigid historical rules. In the year 2026, as the gray divorce trend accelerates, understanding the intersection of these two systems is the difference between a precarious retirement and a stable one. This is where we see a rare departure from the combative nature of property division. Unlike a 401k, where $1 given to an ex-spouse is $1 taken from the participant, Social Security benefits for an ex-spouse do not reduce the primary worker's benefit. It is a non-zero-sum game dictated by federal statute rather than judicial discretion. To understand how this functions, we must look at the 10-year rule. Under Social Security Administration guidelines, if a marriage lasted for at least 10 consecutive years, a divorced spouse is eligible to receive benefits based on their former partner's earnings record, provided they are at least 62 years old and remain unmarried. This is a direct modern evolution of the colonial concept of the widow's pension, which was designed to ensure that a woman who spent decades contributing to the domestic economy of a household was not abandoned by the state upon the dissolution of the marriage or the death of the provider. Imagine a 2026 scenario involving a couple named Richard and Martha. Richard was a high-earning corporate attorney who maxed out his 401k and paid the maximum Social Security taxes for 35 years. Martha worked part-time and managed the family, resulting in a much lower personal Social Security contribution history. They divorced after 22 years of marriage. Under the law, Martha is entitled to collect a divorced spouse benefit equal to up to 50% of Richard's full retirement age benefit amount. The most critical detail is that Richard's own monthly check is not reduced by a single penny to facilitate this. The federal government recognizes the historical trend of marital interdependence and essentially subsidizes the split. This creates a strategic opportunity in 2026 for divorce negotiations. If Martha knows she will have access to this federal benefit, she may be more willing to negotiate on the division of the 401k, perhaps allowing Richard to keep a larger share of a specific high-growth mutual fund in exchange for a liquid cash settlement today. However, the math of Social Security is fraught with pitfalls that mirror the complexities of the 401k QDRO. If Martha remarries, she instantly loses her eligibility to collect based on Richard's record. If she divorces her second husband, her eligibility for Richard's benefit may be restored. This creates a bizarre legal landscape where marital status in 2026 is often a calculated financial decision based on the optimization of federal benefit streams. This mirrors the 18th century strategic marriages where widows would carefully time their remarriage to ensure they did not forfeit their dower rights or life estates from a previous, wealthier husband. The asset has moved from land to a federal treasury credit, but the behavioral incentives remain identical. As we look toward the future of the 401k in a post-marriage society, we must acknowledge the math of the Rule of 72 and how divorce fundamentally breaks it. The Rule of 72 is a simple formula used to estimate the number of years required to double an investment at a fixed annual rate of return. If a 401k is growing at 7%, it doubles every 10 years. When a court splits a $1,401,000 into two $500,000 accounts, it doesn't just divide the current money, it divides the future velocity of that money. In 2026, an individual in their 50s who loses half of their retirement account to a QDRO does not have the 20 years required for those two doubling cycles to return them to their original trajectory. They are facing a permanent structural deficit in their retirement lifestyle. This leads to a burgeoning historical trend in 2026, the rise of the collaborative 401k management post-divorce. In some sophisticated settlements, ex-spouses are choosing to keep their 401k funds in a single, unified investment vehicle managed by a third-party fiduciary, even after the legal divorce is finalized. They do this to maintain the economies of scale and the access to institutional-grade investment tiers that are only available to accounts with high balances. They essentially remain financial partners while being legal strangers. This is a radical departure from the clean break philosophy of the 1980s and a return to the communal property management seen in early American agrarian societies, where families would continue to work the same plot of land even after a patriarch's death or a family split, because the land was more productive as a single unit than as fragmented parcels. The deep dive analysis of 401k divorce in early American society and its modern 2026 equivalent reveals a system that is constantly trying to balance the rights of the individual with the stability of the family unit. We have traveled from the rigid, patriarchal doctrine of coverture to the hyper-technical, forensic world of QDROs, actuarial tables, and offshore feeder funds. We have seen how the historical dower right was reborn as the ERISA spousal waiver, and how the colonial chancery courts paved the way for modern equitable distribution. The ultimate lesson for the American viewer in 2026 is that the 401k is not a static vault. It is a living historical document, a ledger of your life's work that is subject to the whims of legislators, the volatility of markets, and the evolving definitions of fairness in a courtroom. Whether you are a high-earning executive like Marcus or a dedicated domestic manager like Sophia, the outcome of your financial future depends on your ability to navigate these overlapping layers of state and federal law. But as we conclude this masterclass, a new shadow is beginning to emerge on the horizon of American family law. With the rise of artificial intelligence in forensic accounting and the potential for blockchain-based smart contracts to automate the division of marital assets, the very role of the judge and the attorney is being questioned. We are entering an era where a 401k might be split automatically by an algorithm the moment a divorce is registered in a digital ledger, removing the human element of equity entirely. What happens when the fairness of a divorce is determined by a machine that views your 30-year marriage as nothing more than a series of data points and contribution variables? The transition from the human-led courts of the 17th century to the automated systems of the late 21st century is already underway, and the financial consequences will be more profound than anything we have discussed today. To understand this next revolution in wealth and law, we must look at the emerging cases of algorithmic alimony and the code-based QDRO that are already being tested in experimental jurisdictions. The battle for your retirement has only just begun, and the rules are changing faster than the markets themselves.